So St. Louis City, if you're applying for jobs there, does add 3 more classes that aren't protected here in the county. Those are familial status, that is who you may live with, how many children you do or don't have, sexual orientation, and gender identity or expression. So those last 3 bullet points are not protected by Missouri state law or by federal law, but they are added by the city of St. Louis. Now, depending on the municipality you're applying to, there may be additional protections as well. I'm not sure about those different municipal protections. But let's talk about, in more detail, what exactly these mean. Well, first of all, from an overarching standpoint, they don't just cover the minority classification of those classes. That is to say, it's not just racial minorities are protected, or women are protected but men aren't, or a religious minority is protected. It protects all of those traits, no matter what they may be. So basically, whichever gender you are, you're protected from discrimination because of your gender. Whatever race you may be, whatever your religious beliefs may be, you're protected from discrimination because of those beliefs. Okay? You've heard of perhaps reverse discrimination. Well, that's the shorthand term used for, I guess, more unusual discrimination. That is, a man being discriminated against, a Caucasian person being discriminated against. But those are no less illegal than more traditional instances. So, yes, Ron?
I just remember what I was going to ask you. Since you're on the other side, and it didn't slip away this time. Since you're on the other side of talking to the employers and so forth, my concern is, what's this going to do with all these law regulation increases to starting small businesses and having those things being able to be prosper? Because I see a tendency in this country right now for the adding more regulation, and that means the person that's a small business owner, that it's going to be more of a risk for him to start or her to start a business because of regulation. So maybe you could say something about that.
Well, it certainly is. It certainly are more burdens, more hoops you have to jump through to get your business started. Now, that being said, these protections don't apply to every employer regardless of size. In order for the state laws, that is the Missouri Human Rights Act, to apply, the employer needs to have 6 employees. So if it's a very small company, even with 5 employees, you don't have to comply with these. Now, for business reasons, you want to be pretty much in compliance, I would think. But strictly speaking, this law doesn't apply. For the federal equivalent to apply, you need 15 employees. And even workers' compensation. If you're in the construction industry, you need to have work comp insurance, even if you have 1 employee. But otherwise, you need 5 employees to be required to buy work comp insurance. So the law, in some instances, does build in a recognition that these are burdensome laws to comply with and to administer, and so they don't apply to very small employers. But some of them do, such as workers' compensation, retaliation, whistleblowing often applies to just one employee, a company with 1 employee. So you're right, Ron. It's very rare to hear about statutory schemes being done away with or regulations being done away with to free up small businesses to use their business judgment more. Usually you hear about more laws and more regulations being piled on. And that's just, I guess that's just the way it is for small business and entrepreneurs these days. So let me continue talking about what these classes mean. Religion means religious beliefs and religious practices, or the absence of them. So basically, if you hold any religious belief in subjective good faith, that is, if you believe it or you don't believe it, that's protected. The law also treats, and this is an interesting commentary, the law also treats religious practices as something of a disability in terms of the employer's obligation to accommodate them. So if you have religious practices that require you to do things on a daily basis or do things on special holidays and you need time off to do them, the law treats that as a disability in terms of your employer's duty to accommodate that. You don't have an absolute right to take off work, either for, say, 10 minutes during the day or for a special feast day. But the employer has to accommodate you if it doesn't impose an undue burden on the employer. Sex means gender, the status of being a man or a woman. It also includes pregnancy. So you hear about women saying, well, I don't want to be interviewing while I'm pregnant. Well, pregnancy is a protected characteristic, so an employer can't discriminate against a woman because she's pregnant, or even against a husband because his wife happens to be pregnant. Gender also includes what's called gender stereotypes. So this gets into, these protections that St. Louis City has, even though they're not explicitly there. Gender stereotypes means what we generally expect, how society expects a man to behave, how society expects a woman to behave. And if you don't conform with those, that's protected. So that is to say, an employer can't reject you as a man because you're not manly enough. Can't reject you as a woman applicant because you're not feminine enough. So gender stereotyping is protected. So it's a broader protection than just the biological status of being male or female. Age means over 40, which sounds rather young these days, but when the federal protection was passed, I think President Kennedy passed it in '63. And I suppose back then, relatively speaking, being 40 years old was relatively older than it is now. But if you're under 40, you can be discriminated against because you're too young, or even relatively speaking because you're too old. But once you hit 40, you are protected. Now that protection ends under Missouri state law when you're 70, but under federal law, there's no age cap. So basically, the status of being over 40 is protected. You can't be discriminated against in favor of someone younger. Yes, sir.
Got another one. Along those lines about putting the year or years that we got our degrees in college, I mean, it's not going to take anybody too much. They're going to have to take their shoes off and figure out our age there. Do we have to list years that degrees were earned?
I suppose you don't have to, and you're right. If you go back in your employment history or your education history, an HR person can easily do the math and figure out, well, this person's about 50 or about 45 or whatever. Sometimes they will want verification of your employment or your education history. They may ask for a transcript from the bursar's, not from the bursar's office, but from the university or the school you attended, which is obviously going to have your days of attendance. I would say if they ask, give it to them, because they do have legitimate reasons. They want to generally prevent resume fraud, and there have been some, high-profile cases. I think about 10 years ago, the Notre Dame football coach, who was just the football coach in the off-season for a couple weeks, because they found that he had, I think he had misrepresented that he got a degree at some university and completely fabricated it. So prospective employers are sensitive to this, and they just want some backup and verification that you did actually earn this. And I think it's inevitable that if someone wants to do the math, they're going to be able to determine you're over 40. Disability. Disability is very broad. Disability includes physical disabilities, mental disabilities, having a record of a disability, which can even include rehabilitated alcoholism. So alcoholism is a disability as long as it's you're cured of it or you've been rehabilitated. So if you're a current alcoholic, you currently have a drinking problem, that would be legitimate grounds to not take you on with your organization. But if for some reason it comes up that you've been rehabilitated for it, that is protected. So status of a disability, whether current or past. Now, disability means a long-term or a permanent condition. So something like pregnancy is not going to be a disability even if there's complications and the woman is incapacitated because pregnancy only lasts 9 months. Breaking your leg, well, you're going to be incapacitated for a while, but that's not going to be a disability because you're going to get it fixed and it's going to be as good as it can be. It needs to be a permanent or long-term physical or mental condition that interferes with your ability to do the job. Now, we've heard about reasonable accommodations too. The employer has a duty to reasonably accommodate your disability. That is, work with you, interact with you to determine if there's anything that can be done to help you do the functions of the job. So there are certain disabilities that are going to disqualify you from certain positions, and that's just the way it is. For instance, if you are physically disabled and you're in a wheelchair, well, there are certain positions you're not going to be able to do, certain physical positions that require a lot of walking or running or physical activity that you're just not physically going to be able to do, and you're not going to be able to do them. Now, the question is there a reasonable accommodation that can be given you to help you bridge that gap? Now, reasonable accommodations are going to be very circumstantial. They're going to depend on the circumstances of the position, but basically, if they require a lot of money from the employer to buy you something, then they're not going to be considered reasonable. One of the examples is, well, give me a full-time assistant. Well, a full-time assistant is not going to be a reasonable accommodation. Now let's talk about some other protections you have during the actual application and interview process. Someone asked a question before. It's a good general thing to talk about. But let me first say that no interview question in and of itself is illegal. Okay? We hear about illegal questions, and they're certainly inappropriate questions, but no question in and of itself is illegal. And that's because the law requires that you be discriminated against in order to have a claim. Well, discriminated against means that you've been treated negatively. You've been treated adversely, what the law calls an adverse action has taken place. An adverse action, for our purposes, is not getting the job. You've been rejected. Or when you have a job, you've been, your pay's been cut. You were passed up for a promotion. You were harassed. You were discharged. Something concrete has happened to you in a negative way. And you being asked a question is not going to be considered an adverse action. Now, it's not good practice for employers to ask you certain questions because they don't want to know the information. But technically, if you were asked something completely inappropriate, such as, are you pregnant? Are you married to someone of a different race as yourself? You know, those questions would be inappropriate, irrelevant to the job that you're applying for. But those in and of itself wouldn't be illegal.